Hello, everyone. My name is Sandra Ephraimson. Who am I? I am a woman first, child of God. I am a wife. I am a mother, and I am a nurse. Welcome to my new channel called Nurse Perspective. My goal is to bring about information that people need to protect our rights as patients, as parents, as we the people. I wanted to get started today by introducing to you a bill that is currently moving in motion at the California Capitol. I want to give a disclaimer first, though, that I am not giving any legal, medical, or financial advice. This is for education purposes only, and it is my interpretation of what I am seeing. So I want to bring to you the actual document, which is the Bill 1993, Assembly Bill 1993. And what I will do is that I will read through it and explain my notes of how I interpret this bill. There's a lot of learning to have when you are learning. There's a lot of learning to go through when you are going through this information. And so my goal is to just give you some things to think about and for you to do your own research. When you start venturing into what is the law, my first recommendation to you is that you look up your state constitution and that you read it whole, and that you also look for the earliest version of the state constitution and look for the actual meaning as defined during the time that it was written. That is very helpful in giving you perspective and history of how things have evolved to where we are now. So this California Legislature 2021-2022 regular session Assembly Bill of number 1993. Please take note of the authors, introduced by members Wick, Aguiar Curry, Lowe, and Aquila Weber. Principal co-authors are Senator Newman, Senator Pan, Senator Wiener. Co-authors, Assembly members Kirk and Stone. Co-author, Senator Todd. This says February 10, 2022. It was actually introduced today, March 10, 2022, as far as I know. Okay, an act to add section 12940.4 to the government code relating to employment. Legislative Council Digest, AB 1993, as introduced by Wicks, Employment COVID-19 Vaccination Requirements. First, they're trying to establish where they're drawing their power from. And they're saying here, existing law, which is not being defined what existing law they're referring to, and the California Fair Employment and Housing Act, which, if you really look into it, an act can only draw its powers from statute, federal statute, which can only draw its powers from the Constitution, and the Constitution can only technically draw its powers from the state constitutions where the people granted those powers. So the people are the actual only able bodies that can grant power. But moving forward to where we are today, according to existing law in the California Fair Employment and Housing Act, or FEHA, establishes the Department of Fair Employment and Housing within the Business, Consumer Services, and Housing Agency and sets forth its powers and duties relating to enforcement of civil rights laws with respect to housing and employment. So this is their in. This is how they establish enforcement from state codes and are setting the precedents that there is authority to use from these establishments or these entities. Following paragraph here, existing federal law. Again, it's not specifying which existing federal law, it's just pointing it out. Now we're moving on to non-governmental organizations such as the Federal Food, Drug, and Cosmetic Act. And it's saying that that's where they're drawing authorization. So existing federal law, the Federal Food, Drug, and Cosmetic Act authorizes the United States Secretary of Health and Human Services, which by the way, if you look up who is the United States Secretary of Health and Human Services, is that position vacant or is it occupied? And if it is vacant, who is the acting Secretary of United States Secretary of Health and Human Services? Currently, the Assistant Secretary would be the acting Secretary, and that would be Admiral Rachel L. Levine. Just want to point that out. So moving on. So according to the NGO FDA and some existing federal laws that we don't know about, we have these writers of this bill have drawn the authorization that the secretary can approve new drugs and products, including vaccines, for introduction into interstate commerce, and authorizes the secretary to authorize vaccines for use in an emergency upon declaring a public health emergency. So all they had to do was declare a public health emergency, and that authorizes the secretary to authorize vaccines and other emergency measures. On February 4th, 2020, the secretary determined that there is a public health emergency and declared circumstances exist justifying the authorization of emergency use of drugs and biological products. The secretary subsequently authorized the emergency use of 3 vaccines, which are not specified. What brand, what formula, what vaccines? What does vaccine mean? Of course, we wouldn't let a good crisis go to waste, right? Because this is the emergency declarations being used to draw the authority on this bill for the prevention of COVID-19, which according to their statement here, the secretary also approved a vaccine for the prevention of COVID-19 in August 23rd of 2021. So you should read this bill on your own because I'm deciphering it. I'll reread the sentence though. The secretary subsequently authorized the emergency use of 3 vaccines for the prevention of COVID-19. And on August 23rd, 2021, the secretary approved a vaccine for the prevention of COVID-19. Which vaccine? Which vaccine did they approve? No accountability, no names, nothing. Moving along. Let's see how they use state codes to authorize themselves to declare state of emergency. Okay, so the California Emergency Services Act authorizes the governor to declare a state of emergency during conditions of disaster or extreme peril to persons or property, including epidemics. On March 4th, 2020, the governor declared a state of emergency relating to the COVID-19 pandemic. Pursuant to this authority, see, they're granting themselves this authority. It didn't come from the people. The governor issued several executive orders requiring individuals in specific employment, healthcare, school, or other settings to provide proof of COVID-19 vaccination status unless specified exemptions are met. So through the use of executive orders, which executive orders are for presidents, why is a governor creating executive orders? Okay, moving on. This bill would require an employer. Okay, here we go. So this is going to require the employer to require each person who is an employee or independent contractor. This is their wordplay, okay? This is their attempt to bring in independent. A lot of people think of that as private or as separate from a public employee. But once you're using these words, you're actually part of this system here, okay? And so it's going to require, so the bill will require an employer to require each person. Okay, so the burden here falls into the employer. And who is eligible to receive the COVID vaccine? So not only will the employer require each person, okay, it will require each employee, each independent contractor, and anyone. Basically, doesn't say anyone, but and who is eligible. They're not even specifying. This is anyone who is eligible, who falls under the category of eligible to receive the COVID-19 vaccine, to show proof to the employer, or, look at this sneaky thing, or an authorized agent thereof. We just created a whole enforcement unit. That the person has been vaccinated against COVID-19. This bill would establish an exemption from this vaccination requirement for a person who is ineligible. That's also to be determined what it is that they will define as ineligible to receive a COVID-19 vaccine due to, here it is, a medical condition, a disability, or because of a sincerely held religious belief as specified, and would require compliance with various other state and federal laws. So they are now offering us their handout. Okay, no worry, there's an exemption. This is not forced. There's an exemption. The exemption is you will have to prove to us, them, the government, the fraudulent government, that your beliefs are as defined by their state and federal laws. Taking our religious beliefs and turning them into the state, making the state the new God. Okay? Now notice here, this bill would require proof of vaccination. Look at this term with hyphens in the middle of proof, of vaccination. This is a term that you will only see certain times. And what I would interpret as to this point, fitting in with the passports. So this bill would require proof of vaccination status to be obtained in a manner that complies with federal and state privacy laws. Okay, so not only are employers required to require, okay, they're required to require their employees, and anyone who's eligible for vaccines. But they have to do it. They're not protected from breaking the law. So if the employer requires their employee in a way that it breaks the law, the privacy laws of federal and state, who's going to protect the employer? Now, the privacy laws are in terms of retaining. So, and not to be retained, that's the proof of vaccination by employer, unless the person authorizes the employer to retain proof. But think about this. The employer is going to require the employee to show proof of vaccination. And if they don't, then they're fired. So the employee is being coerced to authorize their employer to have this information. Why? Because if they don't authorize it, then the employers are actually breaking privacy laws. And it's obvious that they know by them including it in this bill. But this is a way around it, because they're just going to coerce the employer. And I'll show you how. How? What are the repercussions for the employer? We'll get there. Okay, let's go here. So the bill, here it is. The bill would require proof of vaccination status to be obtained in a manner that complies with the federal and state privacy laws and not be retained by the employer unless the person authorizes the employer to retain proof. Don't worry, they will help us. How? This bill would require on January 1st, 2023, each employer to affirm. Well, how are the employers going to affirm? Here it is. In a form and manner provided by the department. So the very same people requiring you to do this are going to also provide for you the form and manner in which you will affirm. And which department? It's not even capitalized. There's no name of department. Are we creating a new department for this too? So here it is. In a form and manner provided by the department that each employee or independent contractor complied. Sorry, I have to put my charger on my laptop here. Complied with these provisions and would require the employer to affirm, probably under some sort of criminal code that they will come up with, that each new, or this might be the code, that each new employee or independent contractor is in compliance at the time of hiring or contracting with that person. The bill would require the department to impose a penalty of unspecified amount. They won't even tell us how much they're going to extort the employer of how much money if they don't satisfy their affirmations in the way that they provide. The bill would require the department to impose a penalty of unspecified amount on an employer for any violation of these provisions. This bill would repeal these provisions when the Federal Centers for Disease Control, which is a non-governmental organization, and Prevention's Advisory Committee on Immunization Practices determines that COVID-19 vaccinations are no longer necessary for the health and safety of individuals. So if you hold your breath for the CDC, then this bill would repeal. Doesn't it sound great? This bill would include findings that changes proposed by this bill address a matter of statewide concern rather than a municipal affair, and therefore apply to all cities, including charter cities. There's actually further detail down the lines. Here it is. The people of the state of California do enact as follows. Section 1. Section 12940.4 is added to the government code to read: A, notwithstanding any provisions of this chapter or any other law, an employer shall require each employee or independent contractor to provide proof to the employer or an authorized agent thereof that the person has been vaccinated against COVID-19. Notice how this time they didn't put the hyphenated proof of vaccination phrase that I pointed out earlier. Okay, continuing on. B, for purposes of this section, the following definitions apply. One, proof means valid documentation. They took it down from that whole phrase, okay, to just proof. And proof means valid documentation of the person's COVID-19 vaccination record, which may be their vaccine card or a copy of or a digital version thereof, as provided by their healthcare provider, the State Department of Public Health, or another state or federal agency. What other state and federal agencies? The ones that they're going to be forming to implement all the other things that we just talked about? To A, vaccinated against COVID-19, this is a definition, means that the person is fully vaccinated against COVID-19 by a vaccine authorized by the United States Food and Drug Administration, which is a non-governmental organization. It's a private entity. It's a group of people meeting in the private to make decisions, to make recommendations. Or the World Health Organization. Where's the CDC here? I thought the CDC held the recommendation in the first place. Now we're redefining what vaccinated against COVID-19 means, and it means authorized by the FDA, not the United States Secretary of Health and of Health Services. It means authorized by the FDA or the World Health Organization. Those are the two authorizing bodies that will determine what it means to be vaccinated against COVID-19. Section B, notwithstanding subparagraph a person is considered vaccinated against COVID-19 for purposes of this section if the person has received a first dose of a two-dose COVID-19 vaccine authorized by the United States Food and Drug Administration, or, here they come again, the World Health Organization. Provides proof of that first dose and provides proof of receiving the second dose of the vaccine within 45 days after receiving the first one. C, 1, the requirement that a person be vaccinated against COVID-19. That's quote unquote vaccinated against COVID-19 pursuant to subdivision A does not apply to a person who is ineligible. We still don't know what that means in terms of how they're defining who is ineligible, because it is still open to interpretation by the state. The very same departments that are already creating this process. The requirement that a person be vaccinated against COVID-19 pursuant to subdivision A does not apply to a person who is ineligible to receive a COVID-19 vaccine due to a medical condition or disability, or because of a sincerely held religious belief that precludes the person from receiving a vaccination. Again, the state is further defining our religious beliefs. Because of a sincerely held religious belief that precludes the person from receiving a vaccination, subject to verification thereof, and in compliance with this chapter and other state and federal laws, including the reasonable accommodations provision of the Federal Americans with Disabilities Act of 1990, Public Law 101336 of Title VII of the Federal Civil Rights Act of 1964, Public Law 88352. So now we are also drawing our power here from federal statutes and federal law. Which was never mentioned before until right now, by the way. The department shall consult with the State Department of Public Health and the Division of Occupational Safety and Health to provide guidance to employers on what constitutes a medical condition or disability or sincerely held religious belief for purposes of subdivision. Wait a second. Where is the healthcare provider? The employers will only accept the guidance from the State Department and OSHA to constitute what a medical condition or disability is. Those are also defined by those statutes. Or a sincerely held religious belief. So you need to notice how they always put this whole wording in there. Sincerely held religious belief for purposes of this subdivision. Why? Because in this way, they trick you into trying to defend your religious beliefs as if you need to prove your connection with God outside of you. This is the way that they trick you. D1, proof of vaccination. Look, there it is. It is now hyphenated this time. Status. This is proof of vaccination status. This is now a status. Required pursuant to this section shall be obtained in a manner that complies with federal and state privacy laws and shall not be retained by employer unless the person authorizes the employer to retain proof. We talked about this. The employer is being required under penalty of God knows how much money to require their employees, but they can't do it without the employee's permission. So please think about that if you're one of the employees when time comes to make a stand. Two, an employer or authorized agent. Here's our authorized agent. Out of nowhere. We're talking about employers. Those are the ones that are being required. But now we also have authorized agents obtaining proof of vaccination statuses. An employer or authorized agent that obtains proof of vaccination status pursuant to this section shall not share, transfer, or sell that information with or to a third party. But why do we need agents? Is it for all the other eligible COVID-19 vaccine recipients? I hope you guys are getting something out of this. The department shall provide guidance to employers on how to obtain and protect this information. What department? What's the name of the department? Which department? It's just a department. E1, this section applies to both private and public employers. Listen to this. This section applies to both private and public employers. So now they're attacking the private sector by involving the private employers, or in this wording. But let's look at this. Well, here's the definition section, right? Well, public employer, yay, we got a definition for that. A public employer for purposes of this section means the state and every state entity, including but not limited to the legislature, the judicial branch, the University of California, and the California State University. Now, where is the definition for private employer? Not there. Not there. B, a political subdivision of the state or agency or instrumentality of the state or subdivision of the state, including but not limited to a city, county, city and county charter, city charter, county, school district, community college district, joint powers authority, joint powers agency, and any public agency, authority, board, commission, or district. Boy, did that escalate quick. On January 1st, 2023, each employer shall affirm. We still don't really know what the penalty is if you don't correctly affirm. But here we are. Each employer shall affirm in a form and manner provided by the department that each employee or independent contractor is in compliance with this section. So the burden here falls into the employer to ensure that everyone's compliant. After January 1st, 2023, each employer shall affirm in a form and manner determined by the department that each new employee or independent contractor is in compliance with this section at the time of hiring or contracting with that person. The department shall impose a penalty up to blank dollars. It could be anything, however much, to extort you. The department shall impose a penalty of up to blank dollars on an employer who violates this section. And reminder that the form and manner in which they will affirm has still not been disclosed. So how do the employers know if they are violating the section up to this point? The legislature finds and declares that protecting the public health and well-being of the people of California by requiring proof of vaccination, no hyphenation here, against COVID-19 for employment pursuant to this section is a matter of statewide concern and is not a municipal affair, as the term is used in Section 5 of Article 11 of the California Constitution. Therefore, this section applies to all cities, including charter cities. This is all word magic and tricks, okay? Because it doesn't apply to the Constitution, it only applies to cities and all municipal and all the other charter cities. They're just different jurisdictions. This section shall remain operative until the Federal Centers of Disease Control and Prevention Advisory Committee on Immunization Practices determines that COVID-19 vaccinations are no longer necessary for the health and safety of individuals, and as that date is repealed. So we will continue to hold our breath until a non-governmental organization called CDC and their Immunization Practices Committee decides that the vaccines are no longer necessary. Conflict of interest, anyone? Okay, let's wrap it up. Section 2, the provisions of this act are severable. If any provisions of this act or its application is held invalid, the invalidity shall not affect other provisions or applications that can be given effect without the invalid provision or application. They are pushing thousands of bills every week. No one really knows or has time to really see what's in them. By the chance that one of these bills gets out there and people see about it, they put these types of provisions here so they can just kind of not lose all the work that they've done to this point. This is why it's difficult for people to understand or comprehend where we are in this situation. But it is all fraud and a play on the people because the people are not knowledgeable enough in how those powers were drawn and how they are drawn from the people. It comes down to us, the people. We have to understand, comprehend that it is up to us to make a stand. And as I told you earlier, this is not legal advice. It's not medical advice. It's not financial advice. I am not part of the private organization, the Bar Association. I am not part of that. So I'm not a lawyer practicing any law. as defined by them. I am one of the people exercising my rights. All right, hopefully that was helpful to you. I will be bringing in more information that can be helpful when facing these types of challenges in both legislative policies and hospital policies. So I really truly hope that you found some value in this information and look forward to serving you next time. Have a wonderful day. Bye.